May it please the court. My name is Maureen Serber, and I'm here on behalf of Mr. Haygood, the appellant. I would like to reserve 5 minutes for rebuttal.
Okay.
Mr. Haygood was charged with and convicted of second-degree murder following the death of his girlfriend. At the trial, the defense counsel argued for that manslaughter was a more appropriate verdict, but obviously the prosecutor was arguing for second-degree murder. The issue in this case arises with the second element of both of the crimes, the act. And for second-degree murder, you need to have a criminal act, specifically be caused by the criminal act of the defendant. But manslaughter only requires an act or acts. Specifically, defendant intentionally committed an act or acts that caused the death of the victim. It doesn't have to be a criminal act. It can be criminal or non-criminal, but second-degree murder must be criminal. So in this case, the issue arises during the rebuttal closing arguments of the prosecutor. He distinguishes the act element of both crimes in his rebuttal, and I'm going to actually read his argument. Number 2, caused by the criminal act of the defendant. That's different than manslaughter, isn't it? Isn't the act here different? Doesn't this require a criminal act? Committed an act or acts for manslaughter. Defendant intentionally committed an act or acts that caused the death of the victim. Yet murder, the act has to be criminal. Wasn't the act in this case criminal? Putting your hands around somebody else's neck, isn't that a criminal act? Mr. Piazza gave you an example of manslaughter on a 5-story building, 5-story windowsill, and somebody knocks or even if they're angry and they punch the flower pot off, that's not a criminal act. That's not a criminal act. But putting your hands around a 110-pound defenseless female...
Well, it seems like to me this whole argument that he's making is to explain to the jury why this constitutes second degree, because this was a criminal act, not why it isn't manslaughter because it was a criminal act. But his focus is on...
Yeah, I think he was trying to do that. I don't think this is a misconduct type of issue.
Right.
But the way it came out was not that way. He's basically telling them manslaughter, non-criminal.
Well, I guess what I'm struggling with here is the jury had proper instructions. This illustration, the context in which it was done, did not suggest, as I read it, that he couldn't be convicted of manslaughter because this was a criminal act. I mean, I think you're saying, well, because he explained the nature of an act that would have been manslaughter that was non-criminal, that they're going to extrapolate from that it can only be non-criminal. But they'd have to just ignore the instructions. So how,
I think they can follow the instructions but still misapply the law based on the example, because they're going to come back to the example. Oh, he said this wasn't criminal, and and if they find that the choking and the acts are criminal.
I can see why a jury would decide that's not manslaughter, regardless of whether that was criminal or not.
Possibly, but it's not a slam dunk second-degree murder either. It's not similar to I shoot you 5 times, I stab you 7 times. It's more. I think it's more gray because. I mean, if you would headbutt somebody, you wouldn't suspect that would be cause them to die, or I don't think you would. Now, even the choking, I think that's the most serious thing.
Yeah.
I see your point. Even the choking is the most serious thing, but there's no evidence that she wasn't choked to death. It was kind of like, I think he headbutted her, and she got back up, and then she choked her, but he didn't choke her to death, and then. I think he knocked her feet out from under her, and she hit her head this way, and then and then they were sitting near each other, and so it's kind of like somehow a second-degree murder, depraved murder is I continue to beat you and I beat you and I beat you, and he was sitting next to her, and then he was still angry at her, and he elbowed her. So it's kind of the situation is not a slam dunk either way. So that's why this is so crucial and not harmless.
Well, let me ask you this, Mr. Because as I read the record, didn't the judge instruct the jury right at the beginning of closing arguments?
Yes.
So right before, because now they're doing it, we're right before closing arguments, the judge goes ahead and instructs the jury. The jury gets to hear the argument, And then at the end, doesn't the judge also
Yes, he
indicate
re-instructs them on the elements,
on the elements
which
of that?
actually re-emphasizes the problem.
But when you think about it, doesn't also part of the instruction is what the judge say, what the lawyers say is not evidence, just rely on the law that I give you. I mean, you still remember this, this road
Yes.
of, that you, so the closing, so the instructions are given right before closing. Part of that instruction would be just listen to the law as I instruct you. What the lawyers say is not evidence. Then we have this part where a lawyer makes this comment. Then you have another instruction at the end. Why isn't that harmless?
Yeah, because it didn't cure the problem. What it did was re-emphasize the problem. I mean, he reads the second-degree murder instruction must have a criminal act, which is true, and it matches what the prosecutor said. But then when they read manslaughter, it just says an act or act. It doesn't even say manslaughter. The manslaughter instruction doesn't say any act. It doesn't say criminal or non. It just says an act or acts. So when we're on the jury and you're thinking, well, what is this like? Is this like, they said it was criminal. Well, if it's criminal, then I think he did criminal things. Well, I don't know if this is criminal or not, because nobody told them.
And let's go back to when the statement was made, there was an objection, and I think the court properly, basically sustained. Then at that point, there was a motion for mistrial. The judge denied it, but then at that point, didn't the judge ask the defense lawyer, would you like a curative instruction?
Yes,
at the time, the lawyer said no.
She said no.
And then the next day, after...
No, actually, she said...
This day?
She did say no, but then, like the next paragraph, she says, actually, can we give a curative instruction? She did ask for it, and then she asked for another one the next day.
Because I thought there was a timing, and clarify that for me, because the judge made a comment, I wish you would have told me this earlier. What
and that was at the end of
that
was at the end of the closing arguments, because when let's see, I think the best way to do it is by page number. She argues, the prosecutor argues on rebuttal. He says this statement on page 428, and she doesn't get up immediately on page 428. She waits till the end of the closing arguments, which is on page 432, so it's like 4 pages later. She brings up the whole issue. And so that's when he said, oh, that's why I wish you would have told me sooner and whatnot, even though it had only been, four transcript pages.
But wouldn't you make the argument that the jury now heard all of this, no objection, later on the judge is frustrated, why didn't you
Oh, I understand
object?
that, except that it was curable. And I think a curative instruction would have totally changed this case, I think. It wouldn't be here. Because I think they could have just said, this is 1 line, 2 lines curative instruction. Second-degree murder requires a criminal act. Manslaughter, the act can be criminal or non-criminal. And that would have taken all the doubt out. But what are they going to do? They're going to go back to deliberate, and they're going to say, oh, this isn't like the flower pot off the balcony. This isn't like the flower pot off the balcony because it's not criminal. This is criminal. This is criminal, and that's not. So we can't rule. We're precluded from choosing manslaughter. So we'll have to go with second-degree murder, and that's the fundamental error.
I think your argument would have been much stronger if it wasn't like what Judge Kelly said. The jury, based on the facts, could have come to the conclusion that this was appropriate second-degree murder.
Right, but that's not a guarantee. I mean, there's no guarantee that what he argued to them on rebuttal, didn't change the entire, dynamic, didn't change the reasonable probability that it didn't contribute to the verdict. There's no way to know. And, I mean, he was very clear, this is different. Isn't this different? And then he goes on, that's not a criminal act. That's not a criminal act. He maybe even could have said all of this.
You can't say beyond a reasonable doubt.
Right.
But for this, the jury could have come back with manslaughter.
Correct. Thank you.
Is that right?
Yes.
Is that sort of the
Yes,
dilemma
that's
we're
it. And
looking
that's the standard, because it's a harmless error standard. That's the state's burden. And I think that definitely is not harmless. Even though there's no argument that this was a misconduct, but it was said, and even though it was said, doesn't mean.
So even if we think, well, good chance it would have been second degree, we have to be satisfied that beyond a reasonable doubt.
Correct.
They would not have found him guilty of manslaughter.
Right, and most of this argument is okay, but when you say, if he had said, even if the prosecutor said a lot of this and then not said, that's not a criminal act, that's not a criminal act, and made that distinction, I don't think there would, the argument would be, I don't think there would be an argument either. But the fact that it was curable and the trial court didn't cure it, that's the main problem. Let's see if I have anything else. No, I'm going to save the rest for rebuttal.
Okay, thank you.
Good afternoon. May it please the court. My name is Donna Koch. I'm here today on behalf of the state of Florida.
Well, help convince me beyond a reasonable doubt that this jury could not have found him guilty of manslaughter.
Okay. What we're looking at first, I'm going to step back just a little bit from the question, but we'll get there. What we're looking at here is the propriety of the judge's ruling denying the motion for mistrial. And when that judge denied the motion for mistrial, what was in his head? This was a clean trial. It was a fair trial. And that's the standard we're looking at. Well, of course, this court's looking if that ruling was an abuse of discretion, but what was the judge faced with at the time he said, no, not going to grant a mistrial? One of the things he had heard, and I think the important parts of the instructions, I will get there. What did he hear in the evidence? There was 2 videotape recordings of the defendant's post-Miranda statements admitting to all the acts. The acts were, and it was what I call creeping candor. It took him a while to get there, but eventually he says, I intentionally committed all those acts. I didn't mean for her to die. And what the acts are is this. He headbutted her a couple of times. She's 5'1", 110 pounds. He's 5'9", whatever, 165. I headbutted her. She fell down. She gets back up. He goes, I put both hands around her neck and strangled her. You know, oh, it wasn't that long, but yeah, I strangled her. And then they sit back down, they talk, she tells him, I'm sorry, whatever. Then he gets up and this is the act that he actually eventually admitted probably caused the blunt force trauma. He stood up and he kicked her legs out from underneath her, which he, in his own words, says, flipped her upside down. So she then bangs, she lands on her head, she bangs her head. And then when she sits back down to him and she's next to him and she's slumping next to him, he thought she was just looking for sympathy. She's slumping because she's beginning to get that hematoma. He elbows her twice in the chest. So the jury's hearing this, but the judge is hearing this when he's thinking about this fair trial. In initial closing argument, and Judge Kelly, I think this is going to begin to address your concerns. In initial closing argument, what the prosecutor does, and there was 2 prosecutors, there was, you know, probably first chair, second chair. The first chair prosecutor gets up and he's explaining the elements of each crime. He's explaining, and this is kind of significant. They have the jury instructions written out on 2 boards that he's arguing to the jury, and he's showing them the elements. He completely explains the elements of second-degree murder and explains why the facts in this case fit those elements of the crime. But he doesn't stop there. What he does, he goes, okay, and here's manslaughter. And he specifically says on page 396 of the transcript, manslaughter can be any act. And he goes, I'm going to give you examples. And what he does, he gives the example of the flower pot. And he says it all correctly. You know, he's talking about it's any act, and he gives the example of the flower pot. If someone's angry, they knock it off. But he doesn't stop there. What does he do next? He gives an example of DUI manslaughter. He says, manslaughter, someone's driving drunk. Clearly, we know that's a criminal act. And he says, they get in the car, they drive, they don't know the person, they accidentally kill them, whatever. That's DUI manslaughter. That's manslaughter. So, to speculate that when the jury gets back into the jury room for deliberations after they've been properly instructed twice with correct jury instructions.
The jury instructions to take back with them?
Yes, sir.
No one's arguing that jury instructions weren't correct.
No, the instructions are correct. Everybody.
The prosecutor's misstatement.
Okay. What was your question? Do I think it was incorrect?
No, it was simply the prosecutor's misstatement.
In rebuttal.
Right.
In rebuttal. So, to speculate again that the jury would only dwell on the flower pot example when they were clearly given an example of DUI manslaughter, which is a criminal act. So they've got one that's non-criminal, one that's criminal. I mean, we can't guess here that reversible error is going to happen because the jury might have only thought about the flower pot. They clearly had examples. Now let's talk a little bit, they had examples of both. Let's talk a little bit about the defense closing. The defense's entire closing, because defense counsel's faced with all these admissions, right? Her entire closing is focused on this was not depraved mind, disregard for human life. This was not second-degree murder. You know, headbutting is not necessarily depraved mind, ill will, hatred. So what the jury learned from defense closing is, okay, we're going to have to go back there and decide. We clearly know for second-degree murder, you need to have these, you know, the jury was well informed with those closing arguments about the difference between manslaughter and second-degree murder outside of the proper instructions. Okay, so now we get to rebuttal. And again, this is argument. This is advocacy. It's not instruction. Many times it was pointed out to them what the attorneys say is not in, you know, okay. So it looks a little confusing, okay? I have read it over 6 or 7 times to figure out what the prosecutor was saying. The jury heard it once, okay? Boom, they heard it once. And to think that they're going to focus on this complicated language that he's maybe fumbling over, I'm not going to admit one way or the other, that the jury's going to be able to really focus on that when they've heard all this other stuff that I just mentioned. It's speculation. And this is what the trial judge, he's sitting there going, okay, I've got a motion for mistrial. Is a mistrial warranted here? Was this a fair trial? And to answer your question, the scenario was, it was after closing arguments are completed, then defense counsel goes, maybe approaches the bench, and she goes, I'm going to object because of a misstatement in rebuttal closing, and the judge goes, you know, why didn't you tell me what was happening? You know, I could have done so. What do you want me to do about it now? She goes, well, I want to move for mistrial. And he goes, well, no, we're not having a mistrial. He goes, how about a curative? She goes, no, it's not going to help. A curative's not going to help now. But then 2 or 3 paragraphs later, she goes, okay, well, tell the jury that you don't need, you know, criminal act for, it can be either kind of act for manslaughter. And the judge goes, look, I'm sustaining your objection, I'm denying the motion mistrial, but I'm not going to give a dissertation on the law. What I'll do is, when they came back the next day, he says, I'll just re-instruct. Well, when they returned the next day with this curative instruction that, quite frankly, wasn't correct and incorrect in the state of the law, I mean, you're reading, you're going, this isn't even right, and that's why the prosecutor objected. The judge goes, no, this is what I'm going to do. I'm going to reread the instruction. And so that's what this judge did. After the fact, fashioned a remedy to save this trial. It was a fair trial when you look at the entire record, and consequently, his ruling, the mistrial, is not an abuse of discretion here, and the state asks that this court will affirm, and if there aren't any additional questions, I will conclude.
Okay, thank you.
Thank you.
I'm going to disagree that it didn't contribute to the verdict, because I think when they came back and during the rebuttal, and he goes on and he explains, this is what we have here, a crime, this is why you must convict of second-degree murder. If somebody had told the jury, yes, manslaughter can also be a criminal act or a non-criminal act, I think there may have been a difference here. I did want to talk about the examples that the first prosecutor did in his initial closing arguments. He talked about the flower pot off the balcony. That was correct. That was a correct example of manslaughter. And then he did talk about DUI, and he talked about, he said that the act was driving. He kind of described, he said it was drunk driving and swerving around, but then he said, well, the act is driving. And then I think he said, he said the act was driving, and he never actually told them, well, it's a crime to drive drunk. Now, I mean, we know that, I know that. But that's true, though. He didn't. But then, it's even still, then you have the argument that it should be manslaughter, that's the defense closing arguments, then you have the rebuttal. So then you still have the error that happens, you know, 40 pages later, 30 pages later in the transcript. It kind of wipes out what they earlier said when he's saying, this is not like that, this is not like that, that's not a criminal act. So what are they going to come back, what are they going to think about when they're in the jury, room deliberating? They're going to think about, oh, the flower pot, this isn't like the flower pot, because this is a criminal act, which, I mean, of course you could think that these are criminal acts, but I don't think that you can just say, oh, this was a fair trial and that, no big deal. That's the kind of, no.
But didn't the defense ultimately agree to the trial court's ruling that the judge would just reread the manslaughter?
Well, she asked for a couple of curative instructions. The first one was the first day, which was right after the closing arguments, which I thought was the clearer of the requests, because I actually agree that the next day the curative instruction that came in was a little more, it was wordy, it was too long, it really wasn't as on point as a clear, yeah. I'm not sure that one would have helped too much, but it still, maybe it would help a little. A curative instruction would have helped, but that was totally ruled out. So this court has to look to see whether this is harmless error, and it's not, would be our opinion, and that because it's not, there was an abuse of discretion on the part of the trial court. If there are no further questions, I'm going to ask for a reversal. Thank you.
Thank you. Thank you both. That concludes today's session. Court is adjourned.